kind of the logical place to start, given the title of the panel, is what is a contract attorney and what is a co-counsel? So what that requires us to do is kind of take a very quick look at the various ways in which attorneys get paid. Contract and typical arrangement, or the historical arrangement, was either a solo practitioner, by definition solo, or a solo practitioner who often employed another attorney as an employee or an associate. That would not be a contract attorney arrangement. Neither would a partner, neither would a shareholder in a law corporation. So the contract attorney turns out to be somebody who is an independent contractor, as contrasted to being an employee. And that can occur in a variety of settings, anywhere from sporadic work that one person does for one or more attorneys to long-term regular employment as an independent contractor. Now, co-counsel would be two lawyers for law firms who each have independent contracts with their client. So one's not working under the supervision of the other, they are working really as equals in the attorney-client relationship. Generally, a contract attorney, even though an independent contractor, is working under the supervision of the retaining attorney. Those different kinds of arrangements, as we'll talk about as the afternoon goes on, may have some different implications for your fiduciary duties, your ethical duties as an attorney, as well as your potential civil liability for what happens or what doesn't happen in the nature of the case. Okay. Now, we had our third panelist. She was going to launch into the topic we were going to. If you look at the first page of the materials, we try to look at especially the contract attorney arrangement, from the different perspectives. What are the duties of the retaining attorney? What are the duties of the contract attorney? And what are their duties to the client and to each other? So, yeah. So, I'm going to start off with duties of retaining attorney to the client regarding the contract attorney. And we start off with a basic thing that sometimes gets overlooked. That you have to understand, in my law practice, people come to me when things go wrong. So I very often have this myopic view and forget that 95% of what we do, everything works fine, and the 5% that blows up is what shows up in my office. But that's the perspective I have for the kind of work that I do. So the first thing I think of as a retaining attorney is to let your client know that you're bringing somebody else in on the case who's not part of your office. We generally assume in the practice of law that if you have a law firm, that other members of your law firm, they might be your partners, they might be your associates, may very well work on the client matter. But if the person is not a partner of your law firm, if they are independent, outside, independent contractor, then it is important to actually let your client know, and then somebody outside the law firm will be working on their case. I am not a big fan of those clauses and fee agreements that says I have the right to employ other attorneys, and then they kind of drift on for a while. And even if you have that clause in the attorney-client fee agreement, I still think you should be telling people that you brought in an outside attorney. Number two, you're still responsible for that person's work. So it isn't sufficient to just simply hire a contract attorney, give them a project, and not look at the work. For those of us who use contract attorneys and employ contract attorneys on a regular basis, we can certainly look at less work. And certainly the nature of an independent contractor implies they're doing a lot of independent work and not daily supervised work. But you're going to be held accountable both civilly and ethically for the work product at the end. So somewhere along the line, keep that in mind and we take a look at that. The contrast, say compared to a co-counsel or a partner, is from a civil liability standpoint. Anybody who works on the case is potentially civilly liable to the client if something goes wrong. From a disciplinary standpoint, I'm responsible for myself. My limited responsibility for my partners and my shareholders is if I am on actual notice that they've done something wrong. And my responsibility for employees, for associates, is that I have a duty to supervise their work. And the question is, where will the independent contractor fit on this continuum? And the answer is, we don't have a reported case in California just yet. So I would assume the independent contractor is going to fit closer to the employee associate than to the partner level by definition. Do you want to add?
I totally agree with that. The only thing I wanted to add is that I'm going to talk about the relationships between the retaining attorney and the contract attorney. But a lot of times when we talk about contract attorneys, there's this concept of outsourcing the work. And sometimes it's like that. Sometimes you might call somebody to draft one motion or to research one project, something like that, and maybe never even talk to that person again. But most of the time, contract attorneys seem to have very, very regular relationships with their firms. And the clients know that they're part of the case, they know they're part of the team, they call them, they communicate with them, they act as if they were associates. So it doesn't feel like it's outsourcing. I know that it varies a lot, but for the firms that I work with regularly, I am a known part of the team, to the court, to opposing counsel, to the clients, to everybody. So it's not an outsourcing concept where you're being hidden. So I just wanted to mention that. There's both. There's both.
You want to shift into where it fits with that relationship?
Well, I was going to talk about, hi, Will.
Hi, Will.
I was going to talk about the, generally about what it means to be a contract attorney and kind of how that works. And I think this would be particularly interesting to those of you who are interested in being contract attorneys. I wanted to first put it into context that you hear and read a lot about it being a freelance economy that we have these days since the recession. And the statistics that I've read is that freelance people, workers, make up about 30% of the workforce, and is expected to exceed 43% by 2020. So that's a lot of people working freelance. And I don't have those kinds of statistics for attorneys. But I do know that there are lots of different kinds of contract attorneys. I think that there are contract attorneys that wish they were associates, and they're getting the work that they can get and hoping that that will turn into an associate position. Or there are firms that are retaining people on a contract basis that might read the recent Uber decision and think twice about that. They might think about whether they're really taking an associate and calling them a contract attorney. From my perspective, the contract attorneys that I know and that I've talked to in preparation for this panel are people who have worked at law firms, who have experience, and who, for whatever reason, have decided that they don't want that kind of grind. They don't want billable hours. They don't want to have to be in an office every day, all day. They don't want to have to be called in on weekends. It's usually people with kids who want to go to PTA meetings or participate in community activities, or people with aging parents. So there are people that are choosing to do this because it's nice to have flexibility. And the attorneys who retain us are firms that they might have associates, but they have times when they need extra help, or they may not have associates and they just need help when they need help. They don't have enough work for an associate to have somebody be employed full-time. And they can enter into these flexible arrangements with somebody who doesn't want to be working full-time. So it's a win-win in that way. The other kind is that, for me, I do litigation. There are firms that don't do litigation, like a trust and estates firm that does estate planning or trust administration. They have the occasional trust litigation matter that the client doesn't want them to refer out. So they would bring in, I've been brought in to work on those matters. But they're obviously not going to hire a trust litigation attorney full-time when they have a trust litigation matter once every year. So those are the different kinds of, when I see it, the different kinds of solos and firms that would retain contract attorneys. I have relationships with firms, very, very regular relationships with firms, where I basically do whatever comes up that they need extra help on. And that can mean being assigned to a case and working on all of it. Or it can mean doing one research project. And then I have relationships with other firms where I've gotten one research project and never heard from them again. Or whether they have me do all discovery on one case, and then I hear from them again 2 years later. It really, really, really varies. And the key word for both sides, in my view, is the flexibility that both sides get. And you have to, as a contract attorney, you have to want, I think you have to want that flexibility. If you're really wanting a job as an associate, I'm not saying don't be a contract attorney, but don't, it's not always likely to turn into an associate position. And if they tell you that it is, I mean, it depends on the relationship, I guess. I know for me, I don't want that. I'm happy being a contract attorney. It gives me what I need in terms of flexibility. To prepare for this panel, I talked to to a few contract attorneys, actually a lot. And I just want to kind of tell you, if you're interested, I wanted to tell you about some of them so you can get an idea of how different people work. And I've changed the names to protect the innocent. One attorney who I've called Alice chose to do contract work because she only wanted to work part-time, and she wanted flexibility. She has an elementary school child, and she wanted time for her child and for community activities. She only works around 15 hours a week, and about 10 hours a year, but it varies a lot. I mean, there are times when, I can go a week or 2 or 3 or 4 and not have hardly any work at all, and then I can be working on a summary judgment motion and not have any sleep at all. So you can't always control it. So it does vary, but on a regular basis, she works about 15 hours a week. And she said there are times when she doesn't work at all, and there are times when she works more than 40 hours a week. She said that she values her ability to turn assignments down, which is a perspective that an associate doesn't have. I don't know how many of you have ever had the experience of a partner walking into your office at 5 o'clock on a Friday and saying, have this on my desk by Monday. For me, those days are long gone. But if somebody called me and said that I have an ex-party that needs to be filed tomorrow, they can pretty much count on me, unless I'm dealing with an aging parent, which is the reason I do this. She finds the ebb and flow nerve-wracking, but she understands that most attorneys find ebb and flow nerve-wracking. I mean, even partners in big firms go through times when the big case between Microsoft and Google settles or finishes trial, and you're wondering when the next big one is going to come in. All attorneys have that fear. So I don't know if it's all that different, except that there's no salary, there's no paycheck to fall back on. For her, she said the ebb and flows balance out, and the flexibility for her makes it very, very worth it. And that's how I feel. She told me that the hardest part about being a contract attorney is wondering about her future career path. Because for practical purposes, there is none. And if you're my age, I don't worry about that. Because I don't see myself doing this for another 20 years. But if you're 30 or 40, and you worry that you're not on a partnership track, many people I talk to express that fear, that concern, like maybe I should get out and get a job so that I might have a future. But she also knows that those paths are not what they used to be. There's not a whole lot of security in anything anymore, frankly. And I think I don't really know if that's true for associates, but I certainly have that impression.
Let me interrupt for a second on that. I have often, when I started out, I was told that I should go work for another attorney to get experience before I set up my own law practice. And as I thought about it, as I went out job hunting, what I was really being told is I should get a steady paycheck while I'm getting my experience. And it wasn't until many years later that I realized that a couple of the attorneys I worked for were quite economically marginal, and that there's an awful lot of false sense of security by associates. As they walk into the office, they get a paycheck, they get 2 paychecks, but they're not privy to the finances of the law firm. They may not realize how close to the edge that employing lawyer is and looking at you tomorrow and laying you off because there's no income to pay your paycheck. So at least as a contract attorney, you're doing it overtly.
Yeah. You know what you're in.
Right. So, yeah, I just wanted to add that.
Yeah, that's good.
Go on.
Okay, so Barbara, also a litigator, started at a big firm and then went in-house and then quit to raise her children. It's basically the same thing. In Barbara's case, she has 4 primary sources of work, 2 regular sources, and 2 more ad hoc. And that's kind of the way I've been too, up until recently. I had 2 firms that gave me most of my work, and then other firms that would call me more infrequently. She works about 30 to 40 hours a week, which I didn't talk to anybody else who had that kind of steady work. But maybe that's because she has these 4 steady sources of work. The downside to that is that you have to balance. I mean, if one of them wants a summary judgment motion filed and the other one wants a demur drafted and the other one has jury instructions, you're going to have to say no at some point. And, that's sometimes a difficult balance. She did say that when she's really busy, she lets her other clients know in advance. And she seems to work out. And I've actually talked to several people who do have regular relationships with several firms, and that's what they do. They send out mass emails to all of them saying, I'm going to trial, don't call me. If she has conflict, she gives priority to her most regular clients, and always to the cases to which she is assigned. And that comes back to the idea of being assigned to cases and being a regular part of the team. On those cases, I get whatever work comes in. And when interrogatories get served on our client, I get the secretary sends it to me, and I know I'm going to have to draft responses, and I know when they're due, and I know what I have to do to get them done. So, though that always takes priority. Some contract attorneys carry malpractice insurance and some don't, and I'll come back to that because that's kind of a big topic. And also, some attorneys have their own research accounts, Westlaw and Lexus, and some don't, which I found very interesting. There are some that only use the firm's Westlaw or Lexus, and then there are some that have their own. I have both. I have my own Lexus account, and then I use Westlaw through firms that I work for, because I don't know any firms that have Lexus.
Before you go to your next.
Okay.
I was listening to this part, found it very interesting, because there was a several-year stretch I employed contract attorneys, and the pattern I came up with as the one who retained contract attorneys was one who was my first go-to person, and like a lot of established contract attorneys, her idea was flexibility, so she could always say no. And so there was a second one I made sure to give over time about a fourth of the work to, so that if one was unavailable for whatever reason, then I had a 50-50 chance of a second person being available. I never used a contract attorney to take a case from beginning to end. I always gave contract attorneys discrete projects to do. And I don't know how that breaks out, but that's the difference. You know, there's so many different ways to be a contract attorney and so many different reasons to be a contract attorney.
I actually think that's very common, because remember, if you're assigned to a case, every case has lulls. I mean, you get in a complaint, you prepare a demur or an answer, and then, you know, discovery may start, or there are periods when discovery is over, or when a summary resolution is filed, and, you know, 75 days, nothing's going to happen, and you're not busy during those times. So it's not like if you're assigned to a case, you're working every minute. So it doesn't, but you know, I have a lot of being assigned to cases, or I have over the years.
So do you take cases also as a solo?
No, I don't. I have talked to contract attorneys that do. Like they say they do 80% contract and they do 20% their own cases. I personally don't, but that's just me.
So the firms that employ you as a contract attorney, if you use your Lexus account, you charge them a premium or a?
I don't, but that's just me.
Just because you prefer Lexus and you have Westlaw?
Because a lot of firms have California-only databases, and you know, I want to be able to research nationwide. So I chose to get Lexus was cheaper than Westlaw when I did this, and I wanted to be able to research. I think I had a case that was pending in Arizona, and I wanted to be able to research Arizona law if we're talking handicapped.
Following up on his question, if you do mix solo practice with contract work, do you think you create more of a co-counsel type arrangement versus contract attorney?
I think that the people who do that, I mean, I'm not the best person. I've never done that. I don't take any direct clients at all. But it's completely separate. If a client comes to you and asks to retain you directly, you're their lawyer of record, just like anybody else is a lawyer of record. And then if you on Monday work on that client's case and on Tuesday you work on a demur as a contract, it's separate, right?
I don't know what's different other than how you're getting paid. I'm going to throw. What?
Could you talk up a little bit, please?
I said I don't. The question was, what do you do if you're both taking on independent clients as well as taking on contract work? And in my beginning days as a lawyer, 40 million eons ago, I looked at it from the other side, which was I wanted some work, so I set up a private practice. I set it up as a tenant of a law firm, so they fed me work. So I sometimes just did work they gave me as a contract attorney and gave it back. And sometimes I literally showed up as looking as if I were an associate in their law firm. And then other times I took on contract work from outside attorneys. So I think you can do all three, but you have to be careful each time you sign a document that you're presenting yourself the way you're working. And that's where I've seen a number of, actually one of the cases we have in here, the Ellis Law Group case, turned upon in part how the attorneys listed themselves on the pleading paper. So what I'd say you got to look out for on that is that sort of thing. That's probably Well, I'm a firm believer that everybody should carry their own malpractice insurance, just in case. But if you're thinking about how you parse out your malpractice insurance and what you cover and what you don't cover, then, be sure you carry it for yourself as a solo.
That's for sure.
Back before the freelance economy got to be this big, back when the model was, you had job hunters and you had employers, and you had a few, solos. I used to advise young attorneys to present themselves as solo practitioners looking for extra work, because I thought it would give them a leg up on being able to get the work. I'm not sure that is good advice nowadays. And I know the contract attorneys who worked for me, I had the kind of Westlaw program where I could have two Westlaw lines for the price of one. So one was under my name and one was just called assistant. And every time I had a contract attorney and wanted to use my Westlaw account, that's how they did. They came in under assistant. And as contract attorneys changed, changed the password. Question over there?
I don't want to get you out of order too
That's
much,
okay.
but here's a situation. Suppose I'm a trust and estates attorney, but I don't know litigation. And I come up with a probate case where real property needs to be divided in several ways and somebody can't be found. Anyway, it looks like there's going to need to be a partition action eventually to just sell the property, okay? So I want to have probate work and retain the client for that, but I don't want to, get in court. I don't even want to put my name on the paper. Is that an opportunity for contract attorney relationship?
Not if you don't want to put your name on the paper.
Okay.
That's what you're
So what is
Your
it? That's
name-
co-counsel? That's associating counsel? How do you do that?
Well, let's come back and take kind of two snapshots on it. I tell my client, you need to do a partition action. I don't know litigation. Go out and find somebody. Or I don't know litigation, but let me introduce you to my friend Sally because she knows this area. The client goes to Sally, they sign their own attorney-client fee agreement, they do the work, and they bring the partition result back to you. That would be the two basic models. The practical issue that will arise in many of these is, one client, two lawyers, and overlap. And so you don't really fit in the model of either contract attorney or co-counsel, and you have two attorneys working on a client matter with some overlap. So you could choose the way you do. If you wanted to do it through a contract attorney model, and you would pay the trial attorney, the litigating attorney, as a contract attorney, and then they'd come in through your office.
Right.
But
But
your
your
name
name would be on the pleadings,
Yeah.
it'd just be they do all the work.
Yeah.
Yeah.
Yeah, but it's not they would do all the work like, leave me alone, don't talk to me. That's not how
Oh,
it
no, you're
works.
responsible, you got your name on the paper.
Yeah,
Oh,
yeah.
yeah.
So that's why I said I've worked with trust and estates firms
Yeah.
on litigation matters where I'm working on the litigation matter and I'm very actively involved in litigation matters and I have constant contact with the attorney that I'm working with in terms of strategy and everything. And the attorney's name is on the papers. I mean, just about everybody knows that I'm working on the case too, but,
And your name is not.
well, sometimes it is, sometimes it isn't. Again, I've done entire cases. I had one case where I was retained to oppose a summary judgment motion. And then the case went into discovery and the case went to trial and then it went into appeals and I worked on all of it without anybody but the client knowing I existed. My name wasn't on anything. I never had any contact with the court or opposing counsel. It was all ghostwriting. And it went on for years.
And some of those go on like that where you meet with a client. Some of those go on like that where, from the client's vantage point, you're just a name on somebody's bill. Because you funnel all your work into the retaining attorney and don't deal directly with the client. So
But I
Sure.
think that's rare. I actually think, I mean, I really shouldn't say, that's rare for me. I have client contact all the time, but I have opposing counsel that don't know I exist.
Right, and it sounds like you work for a big firm, so most of your project, no. Okay.
No, I work for very small firms,
Oh,
for
okay.
solos.
Okay.
But if a client asks me to draft interrogatory responses, I can't do that without talking to the client.
Right. Right. Yeah, but, that's, discovery is sort of a part of a larger case.
Yeah, I wanted.
As opposed to
yeah.
a situation where you've got a litigation thing that's part of something else, but not dependent on it.
So kind of the good lawyer and the bad lawyer, I know lawyers who will take the contract attorney and say, here's a box of papers, here's the interrogatories, cut the first draft. Then, the good attorney, of course, will then look it over, bring the client in, interview the client, and do the second draft. Then there's the bad attorney who'll say, well, that's good enough, and just give it to the client to sign.
Right.
Yeah.
Yeah.
So, yeah, there's so many different ways to do it. And, the concept of contract attorney is a model that fits a certain number of people. It doesn't fit every possible.
There's really a lot of
Yeah.
variation. So let me go on and tell you the next two types that I have. So the next person, whose name is Shelley, but not really, has a very busy practice of her own. And 80% of her work is her own clients. But she has a specialty, some kind of very unusual software licensing specialty, and she gets called by firms and in-house lawyers to help them out, and she does that on a contract basis. And I suspect that there's actually quite a bit of that. I never knew anybody who did that before I started preparing for this panel, but I do suspect that there's a lot of that out there. Solos who help other people and get paid hourly. So the last person that I want to talk about, I will call Mary. And Mary is a 6 or 7 year associate. Went to Harvard or Yale or one of those schools, and went to work for big firms, actually more than one big firm, and I somehow never really succeeded there and decided to do contract lawyering. And it was very pessimistic about the whole thing. For her, it hasn't worked at all. She told me that the clients want to, that she has no problem getting clients, but it doesn't last, that they want to use her up and spit her out, that a lot of firms are trying to create an underclass of contract attorneys who they mistreat and take advantage of. She was relatively unusual in the group of attorneys that I spoke with. And so that kind of takes me to what I think is a really important point, is that in my world, the attorneys who retain contract attorneys are busy. If they weren't busy, they wouldn't be looking for a contract attorney. They don't want to babysit. They don't want to handhold. They don't want high maintenance. They don't want to worry about deadlines being met. They want to know that you're going to do what you have to do, and that you're going to hand in good work product, and that you're going to be responsive. Now, that doesn't mean that in having relationships with attorneys over years, there are times when you're going to draft an opposition that they're not going to be happy with. I mean, of course, that happens just like any associate. But generally speaking, they're not hand-holding. They're not. I suspect that Mary was a little too high maintenance, and that the lawyers didn't want to. And that's exactly opposite of why an attorney would hire a contract attorney. They're busy. Okay, I made that point.
It's funny, I have the same attitude towards my associates.
Well, I mean, it's just logical to me. I mean, they're not there to take care of the contract attorney. The contract attorney is really there to take care of them. to meet their needs. But let me just finish one thought. You know, when I said at the very beginning that it's or when Elvis said at the very beginning that I think it's a win-win relationship, I really do think it's a win-win relationship because both sides want freedom and flexibility. The firms don't want to have to hire an associate, but they want somebody they can turn to when they need them. The contract attorney doesn't want to have to work every day, all day, and whenever somebody else wants them to, but they want to make a living. And the key there is, the key to these relationships is communication and trust. And things don't always go well, and you talk about it. So I think it's a relationship building relationship. And that do you know what I mean? It's key. Nobody's out there to do the other person any favors, really. So there's a lot of give and take, there's a lot of communication, and that also goes for the client. There's a lot of strategizing that goes on. I mean, I don't stay out of, I don't just get told, make this argument. I think of what the arguments need to be. I spot the issues and we discuss which ones should take front and center and which ones are gotcha arguments that should not be included in a motion. It's give and take, just like an associate relationship. There's no difference there in terms of representing the client. So Jerry and I have talked a lot about the ethical issues, and I'm going to stop monopolizing everything. The main thing for attorneys, for retaining attorneys, is that if what you really want is an associate that's going to be at your beck and call, then hire an associate. You know, you're not going to get the beck and call thing with a contract attorney, unless it's somebody who is okay with having a full-time job and not having any benefits for future.
When you get a chance, you look at page 4 of the syllabus materials. And actually, it's your homework assignment. So can I read this after dinner? And you'll see recorded cases that span kind of the universe of what technically could be a contract attorney. The first one, in the Schaefer case, she literally was a full-time attorney at the law firm, but is an independent contractor. And when it came for some kind of dispute over fees, I guess the client complained about what she was being billed for. The court says, we don't care about the arrangement, we don't care about what the law firm pays her. The law firm can ask for her market rate. Whether they make a profit, loss, or break even is of no import to us. On the other far side is STREIT, I guess that's pronounced straight. The appearance attorney, the famous appearance attorney, the jobs that you know, especially when you're brand new and you'll do anything. 8:30 in the morning in Santa Rosa, Justice Court, get on our way. And unfortunate appearance attorney wound up trying to argue a motion for summary judgment, got sued for malpractice, and couldn't bail out and say, look, just talk to the firm that employed me. And the Ellis Law Group case, which is one I should probably read every 6 months just to make sure I understand how confusing people can do business and how it can confuse out. There was some issue that was going to fall on whether the person was an employee or an independent contractor. And the court just kind of looked at all the facts, but the one that stuck out in my mind was the one I recited about a half hour ago, that the attorney showed up listed on the masthead, on the caption, page 1, upper left, listed as if that person was part of, I guess, the Ellis Law Group's law firm, and was then treated as an associate for whatever purpose.
But that was a case where the law firm itself, I think that was the case, where the law firm itself was a party to litigation, and this contract attorney had represented the law firm in the litigation, and then there was an attorney's fees motion. I think that was the case.
That would make sense.
And the court found that the contract attorney was part of the firm, and therefore, and so the firm wasn't entitled to attorney's fees because you can't recover fees when you represent yourself. So that was the issue there. And I think I mean, in other contexts, I think it really makes a lot of sense. Contract attorneys are very often part of these firms. I mean, I'm very much a part of the firms that I work for. I don't see them every day, but when I don't, we miss each other. So, yeah.
Do you recommend notating, contract attorney or
I do.
counsel on, if you are going to be on the pleading, so it's very clear what your role is?
Actually, to be quite honest, that's an issue that I never thought about before I met Jerry.
About a lot of issues after you talk to
Yes,
Jerry now.
that's true. I've learned a great deal in preparing for this. There are some courts that require that a contract attorney be disclosed, and I never knew that. I don't think it's true for all courts. I think it might be true particularly for federal courts or maybe certain federal courts.
Somewhere out there across the country, the issue arises as to whether or not you can involve an attorney in a case and not disclose it to the court. And in some jurisdictions, California does not appear to be one, but some jurisdictions it doesn't matter. California is concerned with, you're the attorney of record, you're responsible, we don't care what goes on behind you. Other courts on the other side of the cesspool say, well, it's a actionable concealment if you don't disclose who drafted this complaint. Although that usually shows up when somebody walks in pro per with a lawyer drafted document. I don't think I would disclose, use the contract attorney label on a pleading.
I don't think you would.
I do not think I would. It comes from the idea that everybody's an attorney at law, and the relationship among the attorneys shouldn't matter. And having said that, I was recently reviewing somebody else's state bar discipline case, and the prosecutor on it was Joe Smith, contract attorney. I thought that was the dumbest thing. It just looked dumb up there. But you read some of these cases and you realize that there are some issues that might turn on what your role is. Probably not too many turn on how you are listed, especially if you're the contract attorney. So,
I mean, there are times when, again, you're working on the entirety of cases, and then there are times when you're ghostwriting everything. So on cases that I'm assigned to, I'm on the pleadings. I communicate in writing with opposing counsel, and obviously in every case with clients. And on my email, it does say contract attorney, and opposing counsel knows I'm a contract attorney. Whether the court knows that I'm technically a contract attorney, I don't think so. I mean, if it comes up, but I'm treated no differently by the court than if I were an associate. But I'm not an appearance attorney. I'm on the pleadings. I'm actively involved in the case. I'm on the service list.
I suppose it's a bigger issue for the employer for fear that they might be deemed actually employing someone and then getting hit with having to pay all the employment taxes.
Jerry's the better person to talk about that, but I think that whether or not they're going to be hit as an employer isn't going to rise or fall on whether or not somebody's on a pleading. It's going to rise or fall on how much control they exercise and the other factors, the Varela factors. So even though I'm assigned to a case and on the pleadings, I could still be in my robe and you don't know it. I mean, I do court calls from home all the time in my pajamas.
You've said a couple times that.
but somebody new, and then they'll come back to you.
Where would you put an of counsel on your pleadings? You're not a part of the firm exactly, you work outside of the office, you're just working part-time on certain things on the case.
Question is, where would you put of counsel? I'm not sure. I suppose it could either be as part of the main listing, where you have the first attorney's name, Jerome Fishkin, attorney at law, Joan Presky of counsel, and we have one listing. Maybe you have a separate listing, so pleadings get served on two. Some of what we call independent contractor relationships, if they're long-term and regular, they are functionally of counsel.
Okay, in a particular instance, not
Just-
acting as.
Right. You're of counsel because you have a long-term regular, close regular? It sounded like living with my girlfriend the way it was nice. Close regular and steady or something like that. And this is a good way for me to segue into it. Well, let's go to your question.
Well, just to follow up, just to make sure I understand, California is not one of the jurisdictions that requires you to put contract attorney, right?
I know of no requirement.
Yeah,
Correct.
okay, all right.
It's either, if you're on the pleadings, then you're on the pleadings, you're an attorney, you have duties to the client.
Yeah,
If you're not on the pleadings, you may still have duties to the client, but you don't have duties to show up in court.
okay, so here's my question. A couple times you've said that you know, the relationship really is just sort of like an associate in terms of the, you know, the attorneys dealing with each
Can
other.
be, yeah.
So it's, I gather it's fairly standard that, you know, when you're conferring with a contract attorney or a contract attorney's, you know, conferring with that they're both charging their time.
That could be whether they're contract
No?
attorney or
Okay.
associates. It's, what is your billing practice? What is in your fee agreement? Does your client understand this?
What's difficult?
But are you talking about whether the contract attorney is billing for his or her time to the retaining attorney, or whether the retaining attorney is billing both?
When they're talking with each other about the case, you know, where's it going? What strategy are we gonna use? Whatever.
What I will tell you is, if
Yeah.
you don't have it in your fee agreement, that will be up on the top of the client disputes when they finally figure out they've been billed for two attorneys spending an hour talking to each other. If you have it in the fee agreement, you'll have fewer disputes, but it's still one of the 2 or 3 flashpoints in attorney-client fee disputes. So your ability to charge for the conference does not depend upon whether it's, you know, partner and associate, partner and partner, or, you know, solo practitioner with contract attorney. So, and part of it will turn around on, if you're talking about the client paying the bill, that could be a deal breaker if the client knows this. It's kind of right up there next to, what do you mean you charge me 2 hours to travel to the courthouse? And yeah, right. And in fee applications to courts, it's the kind of time I think a lot of judges probably devalue. Might very well be, you know, and I've got to say, to some extent, when I'm talking to attorneys about this, fee disputes, they look at, what's this case about? It's one thing to have a high-level dispute involving a lot of money in somebody's future and really needing 2 or 3 attorneys on it. It's another thing to, if I look at my kind of practice, where does my time consulting with another attorney versus my role as the supervising attorney cross? And, you know, is it legitimate for me to know the client for 20 minutes, teaching an associate how to handle a case?
But isn't that a question that every partner and every associate, every partner visits every day? I mean, every time you have a consultation with an associate, you may bill the associate's time and not your own, or vice versa, in law firms, large and small. So I don't see that it's any different. I know that when I have conversations with an attorney as a contract attorney, sometimes I bill for that. Sometimes I need to have the conversation because I'm fuzzy on an issue. Sometimes we're having a heavy-duty conversation about whether or not to defer or answer to a complaint, and I gauge it like that. So that's what I charge. But then what the attorney charges the client, I'm not privy to.
So bottom line, going back to your actual question, it doesn't really turn on whether it's a contract attorney
I
or not.
agree.
Just whether it's a legitimate charge in the case.
I agree.
One of the funny things about being a panelist is it's like, oh, look what I've been doing for the last 3 months. I think of the different ways one can be a contract attorney. And how is that different from my being your expert consultant? If I'm an expert witness, that's a whole different rule. But there are some cases where lawyers will consult me because there's an aspect of the case that deals with attorney professional responsibility. So they want that consult. I have been hired to do discrete jobs. Oh, that's what I wanted to remind you of. If you're running in and out of court for specific purposes, remember the limited appearance. And file that limited appearance document and file the substitution when you're done. Because that's one of the key ways that you protect yourself against continuing potential civil liability in a case. But I just did one in Superior Court a couple of weeks ago where I'm actually employed on a limited appearance basis to argue a disqualification motion. And then I have one that sounds like one of your kind of cases in which I'm an ongoing consultant in a case that looks like it'll be a bleak house case and an unwritten name. And there are issues that involve my specialty that the client and the attorney are willing to pay me to talk to the other attorney and pay us both retail.
But I think that's more like, what's the fake name that I give that particular lawyer? The software lawyer that I mentioned. You know, she gets retained by in-house lawyers at big firms and small firms because of her specialty. She has knowledge, and that's more a consultation type thing, or drafting a demand letter or something like that. But she's definitely highly specialized and is turned to as a contract lawyer because of that. But she is good enough that she has a busy practice of her own. So I would never think of myself as a consultant.
So, yes, sir.
You described a limited appearance document. Can you describe that, please, what you're referring to?
Did I use the right term, limited appearance?
Limited scope.
Limited scope, thank you. There is a judicial counsel form that you file in Superior Court that says that I am here for a limited purpose, and this is my limited purpose, and when I'm done with this, I'm out of here. And you actually sign it, the client signs it, or the attorney who hires me signs it, and we file it. So I come in, and I work the disqualification motion, I make the brilliant argument in court, the judge just looked at it, you gotta be kidding, Fishkin. Yeah, then I'm done. All right, now I file a sub-out, substitution of attorneys, I sub out. So it's formalizing the process that in some cases, for some reasons, lawyers appear for limited purposes. I think there's a lot of family law work that works like that, where people can't afford a lawyer from beginning to end, so they show up. Yes, sir.
So your limited scope appearance document in the beginning is basically a going in substitution, and then you have to file your out paperwork as your substitution on the way out.
Right. Now, it just reads different than your typical sub-in, sub-out documents.
Even the sub out one does?
Well, the sub-out one, they tell you to use the standard judicial counsel form for substitution of attorney, and I was trying to figure out what the appropriate language for it would be, so I gave the job to my associate. He keeps putting it on because he can't figure it out either. But yeah, how do I mechanically substitute out of the case? We'll have the client sign a substitution out, and I'll write down there somewhere, end of limited scope engagement. And I'm gone. The advantage to the attorney, of course, is I'm there for a discrete purpose. If he's unhappy with the main lawyer in the main case, I really should not be a target defendant unless I botched my end of it. And once I'm done, I shouldn't be on the hook for anything that goes wrong after I'm out of the case.
Limited scope paper doesn't require the regular attorney to sub out, does it?
No, it just requires me to sub out.
What?
And then I guess
You
I need
sub
to-
in, Or does it require the regular attorney to sub out until you sub out?
Yeah, it's the second time in my life I've done it. I gotta go look at the form and see what it asks for. I don't know. It's a judicial counsel form.
All right.
And I believe there's a separate judicial counsel form for limited scope family law, but maybe not. Yes, no? Question?
Now, versus that, when you have done an association of counsel,
Yeah.
does that attorney then have to sub out and it's ongoing more than a limited scope?
So you start a case, you want help, you associate in a second attorney.
Right. Maybe because of their area of expertise in probate or something versus.
Right. Maybe it's expertise, maybe you just need 4 eyes and 6 hands. And then at some point, maybe the case slows down and they sub out. The question is, who signs those? Right?
Because you're
What was your
filing
question?
the pleadings, but you're filing the pleadings with both firms on it.
Right.
And you filed the association of counsel with the court. Once, let's say, that part of the case is finished or comes to an end, does the firm that you associated in have to sub out?
Yes. Unless that firm wants to be potentially on the hook as attorney of record to the client.
So it's private.
I can tell you, if the case goes to hell, the client files a lawsuit, someone will look through the file and sue every attorney who ever appeared. And then you try to work your way out, of that. Yes, sir.
I'm a solo, and I've been hired as a contract attorney for others. I've also hired people to do contract work for me, just depending on what goes on. I've made special appearances for, I show up and say I'm special appearing for the attorney of record because of whatever, and the court says okay. I've had them do the same thing for me. I've been associated in, where my name's on the pleading, in association with the main law firm. And I've heard contract attorney, special appearance attorney, co-counsel, associated counsel. Are there any specific definitions of what those terms mean? I've done ghostwriting like you, where nobody knows that I exist, but I do the ghostwriting work and hand it to the attorney of record, and then they adopt it as, make whatever changes they want. So what I've done on both sides as the hiring attorney and as the contracting attorney, I've done a wide range of different things under different labels, some of which I give thought to, some of which I never give thought to. It's one of the reasons why I decided to show up today. But I'm curious about it. So is there any concrete definitions of these different terms?
I don't think so. When I was a young attorney and I was, getting these gigs to go out and appear for other attorneys, I started saying special appearance because that's what I heard everyone else say. And I ran into an erudite professor judge who says, technically speaking, you're making a limited appearance because the term special appearance is basically to quash summons. And everybody looked at it and go, yeah, fine, whatever. So I come around full circle and say the term special appearance seems to be accepted widely in superior courts in California. So I think you should be clear what the special appearance is for and lay it out on the record. If your name goes on a pleading and it gets filed, I would go to the next step when you're done with the case and sub out one way or another. So those are the two kind of concrete. If you're going to be in from beginning to end and you want to list yourself as of counsel because that's the relationship, I think that's fine to do it. It's fine to not do it. It does not appear to be any legal requirement in California that you define your role. Just know that once you show up, and once your name is in that file, you want to be real clear when you're done. Understand also that in federal court, they seem to follow the premise that if you appear once in a case, your name shows up on the front of the docket for the rest of their life, regardless of whether you've been set down or thrown out or whatever.
To what extent is there an obligation for the attorney who's been contracted by the retaining attorney to have a written agreement with the client? Has that ever come up?
I'm so glad you asked that question. Because these, I'm gonna reveal my ignorance. These are issues that I knew nothing about until I met Jerry. And
I got a free cup of coffee out of it.
Yeah, and I've been carrying this piece of paper around because we came up with all of, or he came up with all these different scenarios where the written client consent is required, and I never knew that, and I think it's useful information. So you can help me decipher this. So of our 4 scenarios that we came up with, 3 of them require written client consent. The one that doesn't is what I usually do. I get paid by the hour. And I get paid whether or not the attorney that's retaining me gets paid by the client. I just get paid, period. Other arrangements start to touch on the path of fee sharing. And that's, correct me if I'm wrong, because I just learned this from Jerry, and here I am telling you. Apparently, if a contract attorney gets a percentage as opposed to a fixed hourly rate, then that's considered fee sharing, and you have to have written client consent.
You will see in here, see the Chambers versus K. And that's one where Mr. K had a case on a contingency, brought in Mr. Chambers, who was supposed to get a piece of the case. They never got written client consent. Mr. K burned Mr. Chambers. The court says, Mr. Chambers, you get your quantum merit, reasonable value of your services rather than the contract. It happened to be the Rena Weeks case. Yeah, and that cost Mr. Chambers a whole lot of money because he just got quantum merit instead of 18% of the attorney fee. So those are the 2 far ends. Now,
And I've heard of a lot of contract lawyers who are doing it on a contingency, and I've never known any. I mean, just friends, not. And I've never heard any of them tell me that they have written signed client consent. So I'm thinking a lot of people don't know that.
do you want to keep going? Or
Well, we've covered 3 of the scenarios. The last one is where the contract attorney gets paid only when the client pays, and apparently that is not okay either. And you have to have written client consent for that too.
That is considered fee sharing under the rule. So if the employing attorney, the retaining attorney burns the contract attorney, now the question is the contract attorney is still entitled to quantum merit, reasonable value of services. And I couldn't begin to tell you from memory the Nat's eyelash case law on when you have the cause of action against the client versus when the cause of action is against the retaining attorney. But there are some screwball cases in that area. Is all I will tell you. And I have to read them every time to see who you get your fee from in that setting.
I would think as a contract attorney, I get paid by the attorney that retains me because that's who I have a contract with. I don't have any direct contract with the client, so I don't see how I could go after the client to be paid if the retaining attorney didn't pay me.
Well, I'll give you case A and case B. Okay. Case B, Chambers versus K. Mr. K employs Mr. Chambers. He introduces him to Ms. Weeks. And actually, there's part of the case that recites about all the work Mr. K personally did, Mr. Chambers did directly with Ms. Weeks.
But that's different. They have a direct.
Definitely a way to put pressure on the
Right, but the cause of action was against Mr. K, not against Ms. Weeks. Okay. It might have been, could have, but most of the case law seems to say that if you're fee sharing and you're the second one in, you don't have the attorney-client agreement with the client, then your cause of action is against the attorney who brought you in and not against the client. There are other settings that would go the other way, where your only cause of action is against the client and not against the attorney you work for. Having a written attorney-client fee agreement is a statutory requirement under Business and Professions Code 614678. but it's not a disciplinary offense. It only becomes a disciplinary offense if you're fee sharing. And we put stuff in the syllabus here. You're not required to have a written fee sharing agreement if you're a partner, shareholder, or associate. However, if you're an independent contractor, you're not part of the firm. Call yourself a contract attorney, call yourself of counsel, then you are required to have written client consent in order to share that fee. If you don't have the written client consent, it's a disciplinary offense. Although if you look at the two cases we've got in the syllabus, Chambers versus Kay and Huskinson and Brown versus Wolf, you will not see any discipline imposed on any of the attorneys involved in those cases. But you no longer have your agreed upon percentage. You no longer have your agreed upon hourly rate. You get in a fee dispute what you're entitled to, reasonable value of services. That's kind of the 2-minute breakdown. So if you're working on a case and you're supposed to get a bonus or you're supposed to get a percentage, it's your job to get the client consent to it. If you don't, the other attorney can burn you, and all you get is your quantum error. Sobering thought. Any other questions?
So, this is not the particular discussion we're having. I'm just curious. I hope you haven't talked about this as of late. I apologize. I have a practice, partner in a firm. I want to hire a contract attorney. I want to have an agreement with that contract attorney. Is there a checklist or something of things that I should include in that agreement? We talked about that at all.
Well, we haven't talked about it.
Same as an independent contractor agreement.
We've listed in the syllabus 2 or 3 different lawyers' viewpoints as to what should go into that kind of agreement.
Where is that?
I don't think we attached, but I might have a checklist attached.
Well, we talked about the books, the content lawyer books.
No, you know what it is? It's preparing for the panel. We looked at a number of articles on the subject and eventually decided to list them, not to attach those, but to list them in the resource list. There are at least 2 published checklists that I think we put on here. And somebody on a listserv sent me one yesterday, so it showed up.
There's an article in the materials from the Lawyerist called How to Start a Freelance Law Practice. And it has a list of what should generally be included in an agreement. But I have an agreement that I use, and I use it as a template, and I modify it for each relationship depending on what it is. I put in all kinds of touchy-feely things like communication. I make people agree to communicate. But of course, you can't force that. Well, we didn't talk to them. But anyway, this article is pretty good. The other resource that I really like, there's a lawyer back east named Lisa Solomon, Sollomon, who I've never met, but she's been a contract lawyer forever and ever and ever, and she has a blog and a website, and she does trainings, and she's kind of made a business of teaching about contract lawyering, and her website is really quite useful. She's from New Hampshire or Pennsylvania or someplace, so, but I resorted to her materials. She's informative, and I follow her on Twitter. She's a good resource.
Want to kick in?
Is this the list you're talking about?
That's the one we call secondary sources. Yeah.
Page 5 of 5, is that the one you're talking about?
About the
That has this checklist?
No,
that you didn't-
it's right in your materials.
Yes,
It's
page
an
5
I
of
article.
understand that you're talking about that.
Oh.
But you're talking about.
Right.
This.
And the third one, independent contractor arrangement for outside attorney, which I actually think was drafted for insurance companies. And if you go in Westlaw or Lexis and putting something like that, you'll find several contract forms out there. And she said that one article has a checklist. I want to flag a couple of murky ethical areas here. One is that when you work on a case, of course, you know that there's this universe of conflicts of interest because you have the attorney-client relationship with the client. When you become of counsel to a law firm, you inherit each other's conflicts in their entirety. That's just California case law that does not apply universally across the country, but it's California and it's here where we practice. Depending upon your independent counsel arrangement and depending upon your working arrangement, you might find that your conflict of interest exposure is broader than you think, because one of the key tests for conflict of interest or for disqualification from future cases is whether you had access to the confidential client information with the person who seeks to disqualify you. The more plugged in you are with another law firm, if you're working on their premises, you have total access to their computer system, the more likely it is you've accidentally acquired those, at least disqualification, not necessarily conflicts of interest. We went over fee sharing, and now I look at trust funds. And most contract attorneys are not going to be handling trust funds for the underlying client. But if you have your own client, you are accountable to the client and to the state bar disciplinary process for what happens to your own client's trust funds. So be sure that you handle your trust account properly. If you are as bad at balancing checkbooks as I am, do like I've done and hire a bookkeeper, proof it out once a month. We are actually required to reconcile our trust account once a month. And if you're the kind of person who regularly reconciles your checking account, you know how often you find funny things in there that you are sure could never have happened. If you don't reconcile your trust account regularly, let me tell you, your trust account is as likely to have weird stuff in there as any other bank account. And it's an unforgiving kind of process with the trust account. Sometime in co-counsel relationships and certainly in independent contractor relationships on a specific case, if one attorney is disqualified from being on the case, typically the independent contractor and the co-counsel will be disqualified also. As a matter of practice, everybody in your law firm, your partners and your associates, are disqualified from the case. There are very, very few settings where one attorney can be disqualified and the rest of the law firm can proceed with the case. We have time for a couple more questions, or yes?
I just wanted to ask about billing for the contract lawyer's time. You have a contract with the contract lawyer to pay them $100 an hour, and you have a contract with the client that they're going to get billed $300 an hour, for example. I assume there's nothing unethical about marking up the contract lawyer's time.
There's a decision about that on Ontario.
You just attach the contract lawyer's invoice and you call it your time and triple the time, or how do you do
No.
that?
Well, first of all, the pagination is screwed up, that's my fault. Anyway, what's called page 4 of 4, the first case on there, Schaefer, is the one that said there's nothing wrong with marking it up. Number 2, the way, when I use contract attorneys, what I do to keep it simple is I ask them to send me a bill that follows the format of my own bill. And then the bill that comes to me, that's the one I pay the contract attorney off of. Now, the one I attach to my bill, and they follow my format because it shows hours without showing rate. So then we just take their hours and then bill the client for whatever rate is in my fee agreement.
And how the contract attorney bills the retaining attorney, I think varies hugely.
Yeah. Good question? All right.
Jen, I'm kind of on number 7 on the comparing to the co-counsel relationship. I was just wondering, when it comes to a case where you can have 2 attorneys who are solos, and they don't necessarily, they're going to serve the same client.
They're going to what?
Serve the same
Serve
client.
the same
Yeah.
client, maybe perhaps together, and they could do they could be co-counsel or one could be contract counsel to the other. In that case, can you give a little, just like, whatever you have time for, as to what the benefits are of one over the other? I mean, as soon as you're co-counsel, you kind of both have to send your engagement, you have to have a joint engagement letter or something.
You'd have a joint engagement letter, or you probably should have separate engagement letters. You're sending separate bills to the client. You're each doing work. There's the coordination problem. I think, as a practical matter, the biggest problem in co-counsel arrangements between solos is sooner or later, somebody's going to get in an argument with somebody else over who's in charge. Really, really difficult. Now, the biggest problem of being a contract attorney in that setting is you're either the boss or you're not the boss. If you're the boss, you have extra responsibilities, but you're the one that's ultimately going to decide the argument yourself. I have attorneys for clients, and so sometimes in my office we'll bring the client in and say, we have a couple, 3 ideas here, let's kick them around. And I don't try to make out my partner's argument or an associate's argument. I let them do it themselves. But yeah, co-counsel requires an extra level of patience, consideration, and trust.
Yes.
Trust.
And as between the retaining lawyer and the contract lawyer, if there's a disagreement about strategy, the retaining lawyer always wins. They're the counsel. It's just like a partner or an associate, right? I mean, if you're an associate and you have a discussion with your partner about whether to include a particular issue in a motion, and the partner says no, and the associate does it anyway, what do you think is going to happen? So
Just remember, when you get into these discussions with other, multiple attorneys working on a case, be very, 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 very ginger about declaring it an ethical issue rather than a difference of opinion. Because no matter what our role is, we all have ethical duties to the clients. And the minute you label it an ethics issue, you've essentially declared war on another attorney. And it may be, and if it is truly an ethics issue, then you have some dramatic steps you're going to have to take if the other attorney is running the case, or if it's your co-counsel. So I just wanted to warn. There was one. Yes, sir.
I noticed on page 5 of 5, you talk about lawyers organizing into these temp agencies.
Yeah.
How does that fit in with everything you've been saying? I mean, what's the obligation of the temp agency to the client? What's the obligation of the attorneys hired by the temp agency?
All right.
that's a whole other area that probably should have been included in this but wasn't. There are agencies out there to whom law firms and companies turn to get lawyers who are often hired out on, they work for 5 years sometimes as employment lawyers. A lot of times it's IP type stuff, licensing, things like that. And there's more and more of that. And then there are also agencies that will hire people like me to go on an as-needed basis. And I don't know whether those agencies hire the attorneys, whether they're employees of the agencies, or whether they're hiring the attorney as a contract, and then I don't know how they work. But that's becoming really more and more common.
So we're going to stop there. Thank you.